Let's do it. Where's Mr. Brown? Okay. And Ms. Constantine, you might want to move out of the way there.
Oh, sorry.
So, no, you can stay there if you want. Court does call the case. People versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly fine.
felony. That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
Correct.
Mr.
Count
Simpson.
2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. Refrain from saying anything because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from the mobile gas station.
Now knowing what the charges are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I understand
and would
that.
not be shown any favoritism.
Yes, and I would like to subpoena my discovery packet, please.
If at some point in time you wish then to be represented by counsel, you need to make that request to the court.
Okay. I've tried calling the public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4 and WCC pictures. And
sir, I have listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr. Simpson.
Sir, for your own
I'm not on
protection
Social
and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not
I
go
have
to the forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm very competent, Cedric Simpson. You can tell. I'm very intelligent. I have a GED. I got a GED in 2013 in 3 months.
Okay. All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to subpoena my GED from the Adult Transitions Program in 2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29th.
a.m. I will sign an order to.
Can you give me a PR bond, please, Judge?
I'm sorry?
Can I please, I would like to request a PR bond.
This time you can file a motion or somebody can file a motion before the court and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman phone number.
Check with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right. So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a public defender.
Evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right. It'll come back competent, and then we can get this proceeding moving even quicker.
Not going to come back competent. Y'all going to try to.
Before we go off the record.
Y'all corrupt as it. Y'all fucked up, people. Y'all people fucked up.
Okay. Keep moving. All right. Been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video to discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases can supply it directly to him.
Understood.
All right. Thank you.
Costantino appearing with and on behalf of Mr. T. Mr. T, can you state your name for the record?
Michael T. Thank you. He's waving.
Yes, Your Honor. And there's, yes.
Can I stop you? No, go ahead.
I will stop your.
No, you wouldn't. Go ahead.
Your Honor, as I indicated to defense counsel this morning, while we are missing an important witness, this is a case where we would ask the court to be able to proceed under Section 6827C as well as people only on most accounts. So, Your Honor, if I may go through count 1, we would be able to proceed in such manner if the court allowed. Count 2 as well. Count 3, we would not be able to proceed today. So I'm sure counsel is going to ask for dismissal of that count. count 4 and 5 are misdemeanors, so we would ask that those follow counts 1 and 2. Your Honor, that would have been our intent today, is to proceed under that authority. And my understanding is that the defendant's going to waive on those counts.
So just so that I'm clear, he's waiving on 1 and 2, 3 is being dismissed, and 4 and 5 are following.
I thought 1 was being dismissed.
I'm sorry?
I thought 1 was being dismissed.
I'm sorry. Yes, Your Honor. Thank you. Count 1, Your Honor, even though we would be able to proceed if the court allowed under People versus Old Main statute cited, we would agree to dismiss.
All right. So you're going to waive, he's waiving on count 2 with 4 and 5 following, right? Okay.
Yes, Judge, that would be correct. And if I could, I do.
Yes, go ahead.
So my client and I, Mr. Teague and I, have discussed this. It's my understanding that he does understand that the people could proceed under the court rule on the assault with intent to do great bodily harm charge, the felonious assault, and the count 2 felonious assault. And that after full discussions that he is intending to waive his right to an exam. In exchange, the people would dismiss count 1, assault with intent to do great bodily harm. So the waiver would be with regards to count 2, felonious assault. We, the defense, would be moving for dismissal of count 3, felonious assault, as the people are unable to proceed on that charge. The 2 misdemeanors, of course, I've explained to him he does not have a right to have an exam in those matters, so those matters would follow. Is that correct, Mr. Teague?
Yes, ma'am. Yes.
All right. You had an opportunity to have a full and fair discussion with your attorney regarding that. All right. Sir, along those terms, you're willing to waive your right to have a preliminary examination? Yes?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit on counts 2 and the misdemeanors following?
Yes, sir.
You understand that, sir?
Yes, sir.
People also waive their right?
Yeah.
All right. Preliminary examination having been waived. Defendant is bound over to circuit court on count 2 with 4 and 5 following.
Your Honor, with regards to the information, we would stand mute and waive a formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to counts 2, 4, and 5. Counts 1 and 3 being dismissed. Pretrial in this matter will be set for
December 18th at 1:30 with Judge Slay.
December 18th, 2025, 1:30 before Judge Slay.
Your Honor, if I may address one other thing.
Yes.
Your Honor, I want to make sure that at this point, it would essentially just be a warning or request from the court to defendant to make sure there's no contact with the victim. We also want to make sure that he understands that applies to other third parties.
All right.
And Your Honor, my client and I have discussed that today. He is aware, of course, of the no contact order. We've discussed. Sorry, got distracted by Officer Allen. Judge, we have just.
Got the feeling.
Yeah, it happens. We've discussed the no contact order. He understands that he cannot have contact not only with the complainant, but third parties, intending that contact to get back to or involve the complainant. So we have discussed that. It's my understanding he is aware of that. Is that correct, Mr. Teague?
Yes, ma'am.
All right. So, sir, you understand all of those terms in terms of the no contact?
It's no contact. It's no contact.
That's it. No contact. That means even through third parties. I will give you this ammunition. I'm sure she wouldn't care. You don't want that issue if it arises coming before me. I will tell you that Judge Slade does not tolerate that at all. So I'd suggest that you follow the advice of your counsel and make sure none of that occurs.